Hi, we are waiting for a speaker to join. I think he's facing some technical this thing. So just few more minutes, bear with us. So while we wait for Mahmoud to join in, I can see people have already joined in. So I think we can start now.
Hello.
Mahmoud, are you there?
I'm here.
Okay. So hello everyone. Finally, we can start the webinar now. And I can Yeah, so I think we can start the webinar now. So before I introduce our guest speaker, let's briefly talk about the tax litigation landscape in the UAE. Though tax was introduced in UAE in 2018, it's surprising to see how fast the tax disputes have already reached the courts. As some data suggests, between March 19 until April 2020, there have been around 30 cases filed in the courts. And in our estimate, there could be multiple cases lying with the Federal Tax Authority and the Tax Disputes Committee. Our guest speaker for today, Mr. Mahmoud Abuwasel, he has been on counsel on almost a quarter of all TDRC disputes in 2019. He has handled litigation of almost 2 billion dirhams worth of tax disputes. Let's welcome Mr. Mahmoud Abuwasel, Managing Partner, Head of Corporate and Tax Disputes of the law firm Wasel and Wasel. Mr. Mahmoud, over to you.
Thank you for the introduction. So yes, tax laws are new to the country. The procedures manifested throughout 2018 and 2019. When I say procedures, I mean the dispute procedures. And there was a discovery process along the way because the tax dispute resolution committees are unique in the sense that they're a judicial committee, and we rarely have those sorts of committees. Usually committees are internal within an authority. So if you have a customs dispute, you've got a committee within the customs authority, Dubai Customs, for example, and so on. Insurance and banking, there are committees within the regulators. So if you have an issue with the bank, you go to the central bank dispute committee. Here, this committee is independent. The tax dispute resolution committees, or the three of them, are independent. They're governed by the Ministry of Justice. So Um, so how those committees operate along the larger landscape of civil procedures in the UAE, that was a discovery process in of itself. So I've got a presentation here for you. I'll get that up and running. And I want to thank everyone for joining. By the way, I think we've got people who registered. We've got people who are on the Facebook page, I think. So thank you, everyone. Okay. So I was counsel on some of the first cases back in 2018. Well, the first cases back in 2018, and at that time it was difficult navigating because the TDRCs weren't formed until March of 2019. So from 2018 until March of 2019, it was somewhat difficult to navigate how to manage the procedure. But then in March 2019, the tax dispute resolution committees were formed, and in the summer of 2019, processes became a bit more streamlined. A lot of it happens digitally, and that infrastructure for the procedure to occur digitally was created. Um, so most of the work is really for multinational companies or large family offices. I work very closely with a lot of tax advisors because we don't advise on the technical elements. There's a lot of complexity in managing the procedure itself, and then the surrounding legislation with respect to either civil procedures or regulatory compliance or matters of Sharia or constitutionality and whatever else may affect the the conflict of interpretation between a taxpayer and the federal tax authority. So initial comments, this is something we tell clients all the time. As soon as they engage us, look, pay your taxes, pay your penalties, comply with whatever the FTA is asking you to do, comply with audits, and then if there is a disagreement, the law grants a lot of different tactics and strategies to apply with respect to procedures. Um, and we will be having a Q&A session at the end. So I ask you, please, no questions about live matters. The general questions are completely fine. So where we are today is there were about 50, so like I said, there's 3 tax dispute resolution committees. I'll go into this in more detail. But cumulatively, between those 3 TDRCs in 2019, there were about 50 cases. In 2020, so far, there are about 90 cases. Um, After the TDRCs, the taxpayer or the federal tax authority may challenge a committee's decision before the federal primary court, and then the federal appeals court, and then the federal Supreme Court, depending on the value of the matter in dispute. But that's generally the stages. So before the federal primary court, we've seen 12 cases, about more or less 12 cases in 2019, and 31 now in 2020. That's the
Hello, everyone. I think we have lost Mahmoud's voice here. We're just checking it out.
Can you still hear? Should I continue?
Mahmoud, can you please just start just a little bit again? We lost your voice in between, so we missed on few lines. Just 2-3 minutes back here. We're just checking with him. Sorry for this.
Mahmoud, we can't hear you.
Mahmoud, we have lost.
Can you please unmute and mute yourself? I think there's some internet issue from your end, Mahmoud. Can you please turn off your camera, or if you can rejoin, because we can't hear you properly. Can you say something?
Can you hear?
Yes,
Yes, we can hear you.
Okay, I turned the camera off.
Yes, now try turning on the camera.
All right.
And now
How about
speak.
now? Can you hear?
Yes, we can.
All right.
Please.
Good stuff.
Mahmoud, yeah, it's better. Mahmoud, I think we'll have to do this slide again. We lost you in between, actually. Yeah. Mahmoud, we can't hear you.
Hello? Hello?
Mahmoud, yeah.
Can you hear? Can you not hear?
Yes. Mahmoud, yeah. I think there is some problem with the internet connection at your place. Can we start again on this, please?
On
Mahmoud, can you leave the room and join it again? Because I think there's some internet connection at your end, and we're facing this problem that we're losing you at every bit. Can we do that?
Sure.
Okay. Everyone, please bear with us. Mr. Mahmoud will rejoin again. By that time, you can put in your questions on the topic, and we'll be taking those questions at the end. Thank you. Hello, Mahmoud, please say something. I'll unmute you.
Mahmoud.
All right. Can you hear now?
Yes.
Yeah, it's better. We can hear you now.
All righty. Okay, let's get back to this stuff. All right. So, general overview of cases we've seen. Some of these have concluded. It gives you an idea of the procedure from TDRCs to the primary court to the appeal to the Supreme. If a taxpayer doesn't pay their taxes, they could get enforced against. So there's been about 10 enforcement cases, and that's usually an expected process. And there's been one constitutional case, but it wasn't looked at by the Constitutional Circuit. There were problems with the procedure that took place. So there was an attempt, but it never made it through to the Constitutional Circuit. Now, legislation, I think from the audience, there's a spectrum of those who are well experienced and those who are maybe using this as an introduction. So we're covering some of the basic legislation and some of the more nuanced legislation. Tax procedures law, executive regulations on the tax procedures law, and the penalties, right? But also pay attention to the decisions that form the TDRC. So that's 23 of 2018. and the decisions that form the tax dispute circuits at the Federal Primary Court and the Federal Appeals Court. And the reason you should look into these before considering a dispute procedure is you need to understand the authorities and the jurisdiction that these committees and circuits have, right? So if there's a thought process of attempting something that is not as standard, like requesting a judge to provide some sort of payment plan or something for a dispute. Well, and I'm not saying that's possible. It's up to the prerogative of the judge, but is it within the authorities of a TDRC judge? Is it within the authorities of the tax dispute circuits judge at the Federal Primary Court or the Federal Appeals Court? It's definitely within the jurisdiction of the enforcement judge. The enforcement judge can agree with persons on certain payment plans to cover any enforcement issues. Also looking at what stage you can refer to this tax dispute circuit. So an unfavorable ruling by the TDRC, you're generally going to the Federal Primary Court. But if there's an issue of if you have reason to believe that the judge or the panel were conflicted in this manner, in this particular dispute, then you may surpass the primary court to the appeals court and argue that there was a conflict of interest and request the case to be remanded to a different TDRC or to the alternate judge and so forth. And those sorts of nuances with respect to the procedure you will find in the establishing laws of the TDRC and the tax dispute circuits of the federal courts, right? So that's 23, 2018, and then 237, 2019, 238, 2019. And then there's the subject matter legislation, which I think a good portion of our audience is familiar with. International, regional. Not a lot of these sorts of these statutes aren't brought up a lot of times. They are when we feel that there's a particular industry that's not quite as elaborated on, and we would like to use regional clarifications on similar issues. Then other legislation. And other legislation, this is a non-exhaustive list, but you would be looking at the civil procedures law with respect to this is the overarching legislation that governs any civil disputes, right? Now, in some jurisdictions, there is an administrative legislation. We don't have an administrative legislation. We just have a civil procedures law, and there is an administrative dispute provision in there. And when I say administrative legislation, I mean the legislation that governs the interaction between government and private persons. Criminal procedures law, if there is ever an issue of tax evasion or anything along those lines, you'd be looking at the Constitution in certain instances, not all the time. I think there's an exponential attempt to try to bring in a constitutional argument to every tax dispute. It's not something that should be carried lightly. There needs to be a lot of thought process that goes into whether there should be a constitutional argument or not. We look at the Majelli, which is the codification of Sharia law, in case there's an issue that requires some sense of Sharia argument. The federal judicial powers, these are powers that are granted to the judges, or this legislation addresses the powers that are granted to judges. So the powers that are granted to the TDRC judge and the federal court judges. Also, to give you an idea of whether whatever strategy you want to implement is within their authorities and jurisdictions. CBCR and AML, anti-terrorism financing. The AML law is important because if there's an issue of illicit funds, that could essentially create an AML liability. Then there's other legislation surrounding technical elements of taxes, particularly with excise and so forth. So administrative law, again, governing relation between government and private sector. So tax legislation or tax legalities are a branch of administrative law to an extent, right? Customs, that's a branch. Any issues with immigration, identity, and so forth, that's a branch of administrative law. Now, in the past, there weren't as many, there wasn't as much discussion over administrative legislation. A lot of it came into play with respect to public sector parties and their relationship, or public sector employees and their relationship with employers. That's mostly where administrative law would play a role. If a public sector employee has an issue with their employer, a certain government agency, then we would see discussion over administrative law. Now that has expanded significantly with the development of tax disputes, because now we're bringing in discussions of administrative law into the picture. And those discussions are unique because they are, the corpus of administrative law here is made up of judicial precedent to an extent. We're not a common law jurisdiction, so we don't have the concept of precedent per se, but the rulings of prior judges and so forth that create some clarity over how administrative decisions are valid or invalid, what the prerequisites are for those administrative decisions to have effect, what happens if an administrative decision detriments a private sector party in a certain way, and so forth. So there's a lot of background to administrative law and how it plays a role with tax disputes and procedures. The relevant authorities that you'll be looking at are the FTA, and I mentioned the legislation because, again, with any authority, you need to look at what the purpose of this authority is that the legislator has provided, what their authorities are in terms of powers and so forth. So if someone asks, well, can the FTA request me to provide certain information or conduct myself in a certain way? Well, yes, a lot of the powers granted are very wide, and those need to be respected. The TDRCs, so there's TDRC in Dubai, TDRC in Abu Dhabi, and a TDRC in Sharjah. They manage different taxpayers, but those three TDRCs are overseen and administered by a TDRC department at the Ministry of Justice. And until recently, that TDRC department was overseen by the Judicial Inspection Department. It could still be the case, that could have changed, but that was very recently, since February, March. But I believe that's still the case. And the federal tax authority is represented by the Department of State Disputes at the Ministry of Justice when a dispute is referred to the TDRC and moving on. So if you commence the TDRC process, if you object to the TDRC and then challenge before the courts, the counsel on the other end, the counsel representing the Federal Tax Authority, is made up of the Department of State Disputes that's located in the Ministry of Justice. So when it comes to enforcement, once a debt is proven, once the FTA proves that a debt exists, whether it's a tax debt or a VAT tax debt or an excise tax debt or tax penalties, those can be, there's no time limit on making that claim. And this is something that is seen in other jurisdictions as well. So a tax liability that arises could be claimed after a year, 10, 20, and so on. A non-payment could essentially be tax evasion. So again, back to the initial comments, pay your taxes, pay your penalties, and go through the appropriate procedural challenges. But you can see the sort of the extreme penalties that apply in these instances. It's a prison sentence, which is not necessarily a fine. I think the legislator gave the judiciary a lot of powers to define how long the prison sentence should be, but also the liability, the debt that's been proven will multiply by 5 times. That's an exponential multiplication. And when it comes to parties within or outside the UAE, well, we've had cases where parties were extradited from the UAE, like in 2010, Parties were extradited from the UAE to their home jurisdictions for tax evasion in their home jurisdictions. So one would expect tax evasion either here or outside, extradition would be respected. And those are, I think, as much they're words of warning as much as they are um, an elaboration on the extremity of not non-compliance. Now, when it comes to enforcement on within the country on assets and so forth, usually if the general thought is if you have a dispute with a government entity, um, usually occurring over some sort of contract. Let's say a contractor is building a building for a government agency, and the government agency believes that this contractor owes them X amount. What happens usually is there's a trial procedure, right? But because that's a contractual administrative dispute. Here, it's a government debt, and it's proven to be a government debt. So the legislator granted the Director General authority to
Me- Mahmoud, Mahmoud, we have lost you again. Can you please mute and unmute yourself? Maybe you can switch off your video and then switch it on. Yeah. Mahmoud, we can't hear you. Can you please mute and unmute yourself again, please? No, we can't hear you again. Can you try without video, Mahmoud? I think there is some connectivity issue at your end. We still can't hear you, Mahmoud. Sorry for this again. Mahmoud will, I think he's trying. Yeah. Mahmoud, can you unmute yourself, please? Mahmoud, we still can't hear you. Can you try it without video? Mahmoud, we still can't hear you. Can you please log out and log in? Let's try that. We can't hear you.
Sure.
Yeah. Memo. Can you please unmute yourself?
All right, there you go. Can you hear now?
Yeah, it's clear now.
Good stuff. All right.
Memo, maybe we can try, you can switch off your video and then we can continue. Looks like there is some connectivity issue. Yeah.
Can you allow me to share my screen, please?
Yeah. Yeah.
All right. Okay. All right. So when the government usually wants to enforce, if there's a contract, let's say, and the government wants to enforce that the payment that they think the other party to the contractor owes them, they usually go through a dispute procedure, a trial procedure by making a claim against the party and then go through the different stages of court. But taxes and penalties are a debt to the government. So they've been evidenced, and the party then has a chance to challenge them. Because they've been evidenced, the legislator has granted authority for the FTA, the Director General, to issue a writ of enforcement, which is essentially a document that can be taken to the enforcement judge directly for the enforcement judge to seize the taxpayer's assets if the taxpayer isn't making the required payments. And that enforcement occurs expediently, and it could result in the taxpayer having their bank accounts frozen, or any other assets that are deemed substantial to cover the debt. And obviously, a taxpayer can, or the person being enforced against, they can challenge the enforcement. But ultimately, if the debt has been proven and there's no court ruling or judgment otherwise, then the payment will have to be made to an extent. Sometimes there are reasons with respect to priority of prevailing parties. So if a company, for example, is liquidating, and the party has, the company that's liquidating has X amount of dirhams, priority would first go to the liquidator, and then to the employees, and then to government debts and so forth. We haven't had a case where there's been an argument or a dispute over what takes priority, but that's generally the tier or the ranking of priorities. There are reasons for appealing an enforcement decision, but those appeals are difficult to argue. Like, for example, if the funds cannot be seized or sold, that's usually an exception to government facilities, right? You can't seize a government power utility, for example, but rarely would these grounds apply to private parties. One of the questions we get a lot of times is the difference between reconsideration requests and waiver and exemption applications. Sometimes it doesn't even come in the form of a question. We see taxpayers are submitting both together or aren't differentiating between the two procedures. These are two different procedures in the tax procedures law. So I have a breakdown of sort of the main differences, right? And then we'll get into them. So a reconsideration request can be submitted by any person. It doesn't have to be a taxpayer. It doesn't have to be a person who it doesn't have to be a company or so. It could be by any person, so long as that person can evidence to some sort of extent that they are a concerned party of this decision. And that reconsideration can be against any decision by the FTA. Right? It doesn't have to be a private decision. It can be a public decision. And this follows through from the principles of administrative law, where you can challenge any government decision to subject to you having the grounds to do so and following the proper procedures. And what the reconsideration request does is it triggers the dispute procedure, right? So if you want to refer to the TDRC later on, if you want to object to the TDRC, reconsideration request must have taken place. And reconsiderations are usually based on interpretations of facts and law. So you have the taxpayer interprets the set of facts in a particular way, or reads the law in a particular way, and maybe the FTA has a different interpretation of the facts and law, and that's where the reconsideration comes in. And there's an internal reconsideration committee in the FTA that takes a look at this. The time bar for reconsideration starts from when the decision is or when the person becomes aware of that decision. There are questions about awareness when the time bar starts, but it's usually when the decision is made knowledgeable. Exemption applications, on the other hand, have to be submitted by a person who's facing the penalties, right? Could be a natural person or it could be a company, but it's not any person. It has to be a person facing penalties. They can submit a waiver or an exemption application. And it's against a penalty decision by the FTA, not any decision by the FTA. Importantly, the waiver and exemption applications don't trigger the dispute procedure. So if you submit a waiver and exemption application and you get a decision on it, it doesn't fulfill the requirements of the TDRC for obtaining a reconsideration decision, right? And that's a very significant difference. And it's important for parties to be aware that if they do intend on possibly investing time and effort into continuing their challenges before the TDRC and the federal courts, that a reconsideration decision has to be submitted. And where reconsideration decisions are based on facts and law, an exemption or waiver application has to be based on an acceptable excuse. What is acceptable, that is subjective, but it's overseen by a waiver and exemption committee within the FTA. That's a different committee than the reconsideration committee. And the time bar for these starts at the end of the acceptable excuse, which is also very subjective with respect to, well, what is the nature of your dispute, and how do you particularly identify when the excuse ended? What if the excuse ended, but you were never penalized? You were penalized later on. Does the penalty that applies after the excuse ended extend the time bar? And these are the general questions that taxpayers have in this sense. So these are two excuses that are not, well, these are two issues that are not accepted as excuses. Lack of funds or reliance on others are not excuses. And I make a point on this particular provision in the law, because there's an English translation that's generally circulated that says the following shall not ordinarily be considered an acceptable excuse when it talks about lack of funds or reliance on others. The original Arabic text, however, says that the following shall not be considered an excuse, right? There's no ordinarily, there's no exception to this. It's just that is a strict provision. There's no otherwise. So the word ordinarily doesn't exist in the original Arabic text. Another question we get all the time is, what if we don't get a response to our reconsideration request? Now, when it comes to grievances against a government entity, the civil procedures law says that if you, so this is outside tax procedures, right? If you have a grievance against another government agency that doesn't have its own subject matter procedures law, the general overarching legislation is you submit the grievance, you wait 60 days. If you don't get a response within 60 days, then your grievance is deemed rejected. However, when we have subject matter legislation, so the general principle is if you don't get a response on your grievance, it's deemed a rejection. But sometimes we have subject matter legislation that says otherwise, like the CBCR law, which says if you have a reconsideration or a grievance to the Ministry of Finance and you don't receive a response within the certain time frame, that's deemed an acceptance, right? So this is different than the general principle. The tax procedures law doesn't provide whether a non-response to a reconsideration request is a rejection or an acceptance. So there's two trains of thought on this. The first train of thought is you need to apply the general principle that if you don't receive a response, it's deemed a rejection, right? And if you were to apply that train of thought, then you need to calculate that the law says that the FTA will respond or will make a decision within 20 weekdays and then has 5 weekdays to correspond that decision to you. So 25 days, right? You submit a reconsideration and within 25 days, you should get a response. If you take the train of thought that if you don't get a response, it's deemed a rejection, then you need to take into account that the clock starts ticking for you to make an objection, all right? The second train of thought is, well, the legislator did not explicitly say whether a non-response is a rejection or an acceptance, because all that happens is the right to rule on this particular reconsideration request is transferred to the TDRC. And if you apply that train of thought, then there is no time limit, right? If you haven't received the reconsideration response to a reconsideration request within 25 weekdays, then you have weeks, months, or maybe even years to object because you have not received a response. These are two trains of thought, and these trains of thought are discussed in amongst the experts in these fields, and so there's a general consensus that these two exist, but whether one will apply over the other is not sure yet, because we haven't had a decision or a ruling addressing this particular topic with respect to whether a non-response triggers the 20 weekdays to object or whether it keeps the time bar open. And I want to make a comment on working days and business days. You see, the original Arabic text of the law says Yom Amal, and what that translates to, I mean, it could be translated to working day, it could be translated to business day. These are different interpretations, because in Arabic there's no explicit translation for weekend or weekday. It's not something that's generally used in the vocabulary. To describe the weekend in Arabic, one would say the holiday at the end of the week, something along those lines. It gets lost in translation, but something along those lines. However, if you look at Article 45(2) of the Tax Procedures Law, the provision says that if the last day of the time bar occurs on a public holiday, then you should extend to the first business day thereafter or first weekday thereafter. So what that means is, if you were to say that only business days are counted, then there shouldn't be a reason to have Article 45, right? Because any public holiday would be subtracted from the time bar because you're only counting business days. But what this provision shows is that you shouldn't be counting business days, you should be counting weekdays, which are the days of work, right? It's difficult to sort of explain this only in English. I think for audience members that may be bilingual, they can sort of sense the idea here, but the message is count weekdays. If there's a holiday coming in between, we've got the Eid holiday coming up next month, that shouldn't be subtracted from the time bar unless the last day falls on that holiday. Then you just have the first weekday after the holiday, and that's it, right? You don't subtract 3 or 4 days from the total 20 weekdays to challenge or follow any of the time bars. So penalties and court trends so far, most disputes have been over penalties, some disputes over the application or interpretation of tax, some disputes over private clarifications. And when it comes to disputing a private clarification, there's two current positions between the judges. One position is that because a private clarification does not essentially have an underlying value, it's not a tax assessment, it's not a penalty assessment, it's merely an interpretation of the law, because there's no underlying value, then it doesn't fulfill the first requirement of the TDRC, which is that you pay the value in dispute, right? You cannot pay the value in dispute because there is no value in dispute, and hence you cannot fulfill the requirement. But then there's another thought process by the judiciary, which is because this private clarification creates or manifests a value or a liability on the taxpayer, then there is essentially a value in dispute, and a private clarification can be ruled on by the TDRCs. So a taxpayer has an interpretation issue, they request a private clarification.
Mahmoud, Mahmoud, we have lost you again. Can you please, yeah, mute and unmute again? We sincerely apologize for this technical glitch. Mahmoud,
Hi, can you hear?
yeah, we can
All
hear
right,
you.
can you help? Can you let me share my screen?
Sure.
All right, we'll jump right. I'm apologies everyone for this. This hasn't happened before. But we found a solution. Just jump out and jump back in. All right, I'll keep the camera on because I think it doesn't really affect. So private clarification, don't agree. Reconsideration, you don't agree. You want to challenge. At that point, you may be faced with these two particular or these two potential results, right? The first is the judge may say, well, look, there's no value in dispute. I'm not going to rule on the private clarification. The second potential result is the judge will be convinced that there is a value that could manifest out of this private clarification, and hence there's grounds to take this to the TDRC. Another trend is we've had the Federal Appeals Court uphold the primary court and the TDRC on the fact that voluntary disclosures should not result in late penalties in most instances. Obviously, it depends on the conduct of the taxpayer. And we're pending to see, or we're waiting to see what the Federal Supreme Court says. Now, all this, bear in mind, we're not a common law jurisdiction, all right? So any of these positions could change at any time. Any judge could take a different position from their from a superior court or from a lower court. So if there's a judgment by the Federal Supreme Court that says X penalties shouldn't apply on X situation, that doesn't necessarily mean that it's become law. The only time the position would change is if the legislation changes. So just because higher rulings occur, you may see the same disputes occurring, and you may see different judgments occurring depending on the judge and their rationale. The TDRC judges and the tax dispute circuit judges and the Chief Justice, they all serve certain terms. And when their term is over and a new judge takes over, he could have a different rationale and he could have a different way of deciphering the legislation. So voluntary disclosures, since 2019, there have been TDRC rulings that late penalties don't necessarily apply to voluntary disclosures. There's been repeated rulings, and those have been upheld by the federal courts at the primary and the appeal stage, not yet at the Supreme. And the rulings were elaborate. So the judges did explain on what basis late penalties shouldn't apply to voluntary disclosures. Previously, I think in 2019, the rulings were a bit more elaborate. Now they're a bit more brief and concise because it's essentially the same principle, but in a more concise sense. In one case, there was a court-appointed expert who also looked into this issue and had the same finding. So now we wait to see what the Federal Supreme Court says on the topic. And the Federal Supreme Court rules on law, not facts, right? So when whenever you're appearing before a court, a judge, you're arguing a certain set of facts and you're arguing your interpretation of the law. The Federal Supreme Court doesn't look at the facts, just looks at the law. So the Federal Supreme Court could indeed have a different interpretation, um, because well, what usually happens is the Federal Supreme Court, if the dispute is very factually, um, has a lot of facts affecting the outcome, the Federal Supreme Court could remand it to the Federal Appeals Court, so send it back to the Federal Appeals Court to rule again. But if the dispute is over interpretation of the law completely, then the Federal Supreme Court could issue a decision independently without actually sending it back to one of the lower courts. Now for taxpayers, let's just comply with the procedures. If you need to submit a VD, if you find there's an error, submit your VD within 20 days. You've discovered the error now, you've got 20 days, submit your VD. You may get penalties, you may not. If you do, pay everything, pay your taxes, pay your penalties. If you think you have grounds to proceed, then there are a lot of interpretations of the law that are being presented by the judges in the courts. So how does the TDRC operate? You've got, I think I mentioned this before, you've got the TDRC department at the Ministry of Justice. It manages the 3 TDRCs, and then you have, well, the 3 TDRCs are one in Abu Dhabi for taxpayers with an address or a tax address on their certificate in Abu Dhabi, and for out-of-state taxpayers. So an out-of-state taxpayer would be subject to the Abu Dhabi TDRC. A Dubai TDRC for taxpayers with the Dubai address, and the Sharjah TDRC for the rest of the 5 Emirates. And a submission is made, you make your submission to the TDRC department of the Ministry of Justice, and then that department sends it off to the other, or the competent TDRC. The procedure is digital, so it's done via email as of July, August 2019. And the responses you get are also by email, right? So we make a point here that whoever is managing this procedure, whoever is concerned with this procedure, needs to know that a notification by email is deemed, or the person is deemed notified the date the email is sent, not when it's received. All right. So if let's say you submit your objection and you're waiting for your ruling, nothing happens in between. There's no hearings, you're just waiting for the ruling, and the ruling is communicated by email. It's communicated, let's say today on the 17th of June. You're deemed notified as of the date it's sent. Well, not technically, the day before. So the clock starts ticking from the 18th of June. But it doesn't matter when you actually see the email. If you open up the email a week later or 2 weeks later, that doesn't matter. It's the day it's sent. And there's a case on this. I think I mentioned it in this slide or the next slide. But there's a case on this. There's currently an ongoing case with respect to a taxpayer not having received, or arguing that they didn't receive the notification. And the court appointed an expert, and the expert looked at the taxpayer's internal systems and emailing systems and so forth, and found that the email was delivered, but ended up in junk or spam or one of these sort of inboxes. And the taxpayer had no, the judge found that there's no grounds on that end because of the legislation. The legislation, particularly the e-civil litigation legislation, makes this very explicit. Notification by email is deemed complete the day it's sent. During the TDRC process, there could be a physical hearing. You could attend before the TDRC, before the judge, and so forth. Have someone who's aware of the procedure, because you are appearing before a judge. Okay. And when it comes to the emails, whitelist the TDRC emails, whitelist the Ministry of Justice emails. Make sure those aren't going to your junk or your spam inboxes. So there's been a substantial number of objections rejected for non-payment or being submitted outside the time bar. Again, pay your penalties and act quickly. And if the TDRCs reject, the courts will most likely reject unless there's a very there's a material error that could easily be evidenced, right? Let's say, well, I think the examples are limited, so I can't really give an example because these things are ongoing. But as a general matter, if you don't submit your reconsideration on time, the TDRC will reject the objection and the courts will reject the challenges. If you don't submit your objection on time, the courts will reject the challenges. If you don't challenge before a court level on time, then the following courts will reject the challenge. So you need to protect the sanctity of the whole process by complying with every step of the process. The days are if there's a decision for reconsideration requests, right? Not waiver and exemption applications. For reconsideration requests, 20 weekdays from the decision that you would like to be reconsidered, and then after the reconsideration decision, 20 weekdays to submit the objection. And I'm sorry, that shouldn't be 30 days for the federal primary court. That should be 20 weekdays as well. So between the TDRC and the federal primary court, it's also 20 weekdays. Between the federal primary court and the federal appeals, it's 30 days, 30 calendar days, and then between the federal appeals court and the federal Supreme Court, it's 60 calendar days. So there was actually a case where one of the federal courts reversed a decision of the TDRC. The TDRC thought the taxpayer did not comply with the procedure. The taxpayer actually did, and the federal courts reversed it. But those are rare instances. Most of the cases were actually the taxpayer is not complying with the time or paying the value in disputes. So at the federal courts, we haven't seen any remandments so far, and the remandment is when a higher court sends a case back down to a lower court to rule on. So we haven't seen that happen yet. The courts are making their independent decisions, and they've been mostly upholding the lower courts. So most of the federal primary court judgments have upheld the TDRC judgments. Most of the federal appeals judgments have upheld the federal primary court judgments. So rarely do we see any dissent between the different levels of court. There haven't been that many appointment of court, or the courts haven't appointed experts often. I think we're going to start seeing some more appointment of experts now, but at least during last year and maybe the beginning of this year, a lot of cases were argued by counsel before the judge, and that, well, not physically, a lot of it is occurs before the case management hearing office. But a court appointed expert would come in useful if there's a technical issue at play. So if it's a position with respect to the application of tax on a particular transaction or particular products, etc., then an expert would come in handy, right? Because he would help the court decipher the technicalities behind both the taxpayer and the FTA's position. Otherwise, if it's an issue over interpretation of law, then I mean, this is my humble opinion. I don't think an expert would really be needed for interpretation of law. Could come in useful, but what it does, appointment of an expert would extend the duration of the case, may cost the taxpayer. So if there's really no need, unless the taxpayer wants to be extra careful in that sense. But subjective decision to whether an expert should be appointed or not. Enforcements occur quickly. If an enforcement commences, then seizing a taxpayer's assets would happen faster than if it was two private parties litigating. And the disputing parties mostly have been banks or those in the financial industry, banks, insurance, so forth, construction across the spectrum, whether it's a contractor or supplier or so forth, fast-moving consumer goods, and there's been a few high net worth individuals with cases currently in the courts. And that concludes. I think we're on time. I think we're on time, accounting for the few disconnections that we had. I thank you everyone for sticking around. We've got a Q&A session now.
Yeah.
I'm not sure. I haven't seen the questions, so I guess Anu's been compiling some questions for me here.
Thank you, Mahmoud. And we'll be taking the questions now. So we have received few questions in our chat box. And those of you who wish to interact with Mahmoud, they can switch on their videos and we'll unmute them for them to interact. And since we are live on Facebook also, so we have received in few questions from our Facebook viewers. So we'll be taking questions. We'll try to take in as many questions as possible depending upon the time. So Mahmoud, we have a question here. If disputed amount is less than 100,000 dirhams and TDRC has awarded in favor of taxpayer, can FTA challenge this before the court?
Well, the question is twofold, right? Anyone can refer to the court if they believe they have grounds, right? So whether they can, yes, they can. What does the law say? The law says that if you have a decision or a TDRC ruling under 100,000 dirhams, that's final, that's binding, it's a writ of execution. So let's say a taxpayer or the FTA doesn't like a ruling with respect to a value under 100,000 dirhams. And in principle, either one could challenge before the federal primary court. And the defense would be from the other party as this challenge lacks procedural compliance because a ruling under 100,000 should not be challengeable, right? Okay. So when you say, can someone do this? Well, yes, they can. But then it's the taxpayer's role to defend and say the value being disputed is under 100,000, so the TDRC ruling is final, and vice versa.
So there's one more question. It says, how do we submit the waiver applications?
Well, I think there hasn't been a formal procedure that's been created. Well, I mean, you write your waiver and exemption application and you correspond it to the federal tax authority. When we compare the procedure for the reconsideration requests have a particular online stepwise procedure where you fill in certain elements and so forth. There isn't something similar for exemption waiver applications. So as long as that is correspondent and you can evidence that it's been correspondent, then you've complied with what's required to the extent that the FTA is concerned.
Oh, okay. So Mahmoud, here we have a question from one of our Facebook viewers. It's quite an interesting question actually. He's asking, FTA has been issuing clarifications which are retrospective in nature. So is there a way taxpayer can challenge these if we don't agree with their positions?
I can't answer. I have to apologize, but I can't answer that question.
I see.
I think one of the things we said at the beginning, if I feel as if the question has to do with a live matter or something, I'm going to have to apologize.
Yeah, no, I understand, but I thought it's an interesting question.
There's one question, and there's a very interesting discussion, but I can't do it.
It's a controversial question, actually.
I'm sorry?
It's a controversial question, actually.
Well, I don't know about. It's an interesting question because you start expanding beyond the strict wording of the law, right?
Exactly.
But yes.
Yeah, we have one more question, which I think has been answered, but I'll still, put it up for you. How do you calculate the 20 days time period for filing reconsideration applications? Is it 20 working days? And do we exclude weekends and public holidays while calculating this limit of 20 days?
Yeah, I think I talked about, so you're counting weekdays, all right? That's what you're counting. You don't exclude public holidays unless the public holiday is on the last day of your time bar. So let's say June. We don't have any public holidays in June. I don't think there were. Yeah, we don't have any public holidays in June.
Yeah.
So you would be counting every weekday in June. Let's say the end of your time bar falls on Eid, right? Then you would only extend to the first weekday after Eid, and that would be your time bar. So you are excluding weekends because those are generally days when the when the government isn't working. So Friday and Saturday you're subtracting, but you're not subtracting public holidays unless they're on the last day.
I see. Mahmoud, we have one more question here. It says the FTA audit is done by FTA officials. However, the decision they made were based on a misunderstanding. So, how can we try to make them understand? We have applied for reconsideration, but we haven't received any proper replies. So, how to tackle this?
That's a live. That's I'm sorry. No. I'd be happy to help everyone, but we can't. I can't discuss live issues unless we've got. I need to know who the people are, and we've got a whole set of regulations we need to comply with. So
I see. And we have one more question here. What are the common mistakes made by taxpayers in making applications for TDRC and FTA? This is,
what are the common mistakes?
yeah, made by the taxpayers while filing applications for TDRC and FTA.
Well, I think falling outside the time bar and non-payment of taxes and penalties, that's across the board. It happens so often. But what we also see is a lot of objections are technical without taking into account that a judge will be looking at your objection. You're submitting a pleading to a judge, and you need to ensure that that pleading looks like anything else that's submitted to court. That's prepared by, I want to say counsel. I don't want to seem too self-promoting, but you need a lawyer to work on you with it. But at least if it's not someone with some sense of legal background or or anything of that nature. So you're appearing before the TDRC, you're submitting to the TDRC, you're submitting to a judge. Make sure your content is filled with legal grounds and basis to support your position. Another, I think, issue I see is there's a lot of there are a lot of unfounded requests that are made, um, you know, requesting sort of leniency or things along this nature. unless there's a legal backing for your request, then the judge's hands are tied to an extent. But
Right.
it shouldn't be sort of a letter requesting leniency. You're submitting a pleading, which has to be colored with
Yeah.
the respective facts and law that you want to apply.
Yeah, I think you have just answered the next question because someone has asked that do we need a lawyer to file the clarifications with FTA and applications for TDRC? So I think you have just answered that question there.
Is the question, do you need a lawyer?
Yeah, do you need a lawyer to file the clarifications with FTA and the applications with TDRC?
Well, I mean, it depends on how experienced you are. There are companies that have handled these issues independently and were successful. So I mean, it's not a blanket slate. Do you need or do you not need it? Or how much experience do you have in these matters? What is the matter that needs to be that you're concerned with, and so forth.
I see. Uh, in the
Well,
audience, anyone wishes to interact
I
with
think
Mahmoud, you
maybe the
can.
question. I'm sorry. Maybe the question is, do you need a lawyer procedurally?
Uh,
Maybe that's what the meaning. So before the
maybe.
court, all right.
Yeah.
So before the FTA and before the TDRC, um, the concerned person can authorize other parties, irrespective of whether they are lawyers or not, to represent them before the FTA or the TDRC. Usually, companies just take it upon themselves to do it. Before the courts, a company can still represent itself. It could be self-represented, um, but the courts are to do that. You need to express a level of regulatory compliance with respect to the laws governing advocacy and litigation. So a company can still self-represent before the courts, but it's a little harder to navigate.
I see. So, Mahmoud, it's time now, but we have received one more question if you can answer, and then we can wind up the webinar. Yeah. So, the question is, have there been disputes with regard to tax refund requests? What could be the errors from the applicant's side for tax refund requests that reduces their chances of getting the decision in their favor?
A tax refund request would reduce the chances.
What could be the errors from the applicant's side that reduces their chances of getting the decision in their favor?
Oh, well, I mean, you're first looking at direct breaches. If there's an explicit breach, you've lowered your chances. But also to a sense, how are your intentions when you're applying all these procedures? You talk about errors, and are those errors intentional, unintentional? Can you prove otherwise? I mean, there are certain instances where you look at errors that taxpayers have made, and they're unjustifiable. To anyone looking at this set of facts, it's completely unjustifiable that the taxpayer conducted themselves in this way. So it's a bit difficult to argue for removal of any penalties or cancellation of any penalties and so forth. In other instances, you can see a sense of you can see that the taxpayer is a good faith actor, and there was a sense of unintentional mistake and so forth. But this is it's a very wide answer to this, but that's generally the gist of it.
I see. So, thank you, Mahmood, for the webinar.
Thank you.
And I sincerely apologize for the technical glitches, but I hope the presentation was insightful. And we'll look forward to your continuous support in making GCC FinTax successful. Thank you, everyone.
Thank you, Anu. Thank you, everyone. Thank you for keeping up with me as I go back and in.
Yeah.
And whatever I can do, GCC FinTax, I think you're very successful. And I thank you for the opportunity.
Yeah. Thank you, everyone.
All right. Bye-bye. Take care.
Bye-bye.